second, we just, yes, sir. The live streaming has started and the members may please begin the hearing.
Okay. Good morning, good afternoon, wherever you are. My name is Philippe Cavalieros, and I will be acting as chair of this panel today. And I would like to turn now immediately to my co-panelists, who will very briefly introduce themselves as well before we carry on with this. Pedro, perhaps?
Okay, just say I'm Pedro Garcia Correia. I'm sports lawyer based in Lisbon. It's a pleasure to be here today. And of course, I'm going to integrate this panel today and listen to your pleadings. And I just want to wish you good luck to both teams and have a good and pleasant experience here with us. That's what I hope and I wish. Okay.
Thank you, Pedro. Markus?
Thank you.
We cannot hear you, Markus.
Can you hear me?
We can now.
You can, okay. So good afternoon and good morning to all of you. My name is Markus Manninen and I'm an attorney at law in Helsinki, Finland. And I've been also a cast member since 2011. It's a pleasure to be here. So good luck to all of you.
Thank you very much. Now I will ask, please, the appellants team to introduce themselves. Just for the moment, please give out your names very distinctly so that we can take note of them for scoring purposes. And then we will discuss, we will hear obviously from the respondent side, and then we will discuss preliminary issues. So on the appellant side, please, who will be speaking this morning?
Good morning, members of the panel. My name is Jonathan Kilgallon. You can call me Jonny if you would prefer during today's proceedings. And I'll be talking about the procedural issues today, which there are 3 following the order on our skeleton. And you are joined with my colleague, Jakub Kaluza, who's going to speak on the merits issues.
We can see, thank you, Mr. Kilgallon. We have your name written down, but I'm afraid I do not have the spelling of your co-appellant on the council side, please.
So I guess if I speak, you should be able to see my name and the spelling. So it's Jakub Kaluza. Good morning.
Thank you very much. On the respondent side, please.
Good morning, members of the tribunal. My name is Agustina Zapata, and I will present the procedural issues together with Marianne Beyer, who will present the merits issues of the case. We appear before this tribunal on behalf of the respondent, FIFA.
Thank you very much. Same question. Would your co-counsel also just say a few words so that we can write down her name, please?
Good morning, Mr. President. My name is Marianne Beyer.
Okay, thank you very much for your kind introductions. Now, a couple of housekeeping issues before we kick off. You have been told of the special requirements to stay on mute whilst another speaker is pleading this morning, so please bear that in mind. Don't forget to unmute yourself when you speak as well. Now, on the sequence of the parties' pleadings, have the parties contacted each other and reached an agreement as to who will start and for how long? So I'm going to ask the appellant team first to respond to these questions, please.
Philippe, we had some conversations, but we weren't able to come to an agreement as to who should go first or in what order. And with that background, we would submit that the standard procedure is followed, involving the appellants go first and with a 20-minute time allowance and the 1 minute for rebuttal.
Okay, turning to the respondent, is there any objection to this proposal?
Yes, Mr. Arbitrator. From the respondent side, we propose that respondents should go first for the jurisdictional issues, since we are going to challenge the admissibility of the appeal, and it is of paramount importance that this tribunal hear this issue first before the others.
Okay. In terms of timing, do you anticipate a length for your preliminary jurisdictional objections?
For the time allocation, we consider that the time should be 9 minutes and 30 seconds for each pleader and 30 seconds for each rebuttal answer rebuttal.
Sorry, may you repeat, please?
Yes, Mr. President. For the time allocation, we consider that the best option, according to the rules, would be to occupy 9 minutes and 30 seconds for each pleader for merit and jurisdiction also, and 30 seconds for each rebuttal answer rebuttal.
Okay, but my question related to the time you need for your potential jurisdictional objections that you would present to this panel first.
9 minutes and a half, it's going to be okay, as the rules state.
Okay, so the entire jurisdictional objections will be 9 minutes and a half.
Yes.
Okay. Now, I'd like to turn to my co-panelists, Pedro and Markus. And again, feel free to indicate whether you wish to discuss this in a breakout room. But on a preliminary basis, it seems to me that we could indeed start with respondent jurisdictional objections first, and then hear the appellant in response thereto, and then move on to the merits in a regular order, i.e. the appellant first and the respondent to close. Is there any objection to this way of proceedings? Would you like to discuss this in a breakout room? Markus?
Thank you, Mr. Chairman. No need and to discuss this in the breakout room. So I think this is a matter that the chairman can decide. Thank you.
Okay. Pedro?
From this side, I don't need also to go to the break room, and I would agree that we change that and the respondent starts with the pleadings regarding the procedural issues. So I would agree with this change.
Okay, I just have one additional question to the parties with respect to their rebuttals. Should the rebuttals pertain to first jurisdictional issues and then merits issues, or should there be one rebuttal for the entire pleadings?
Mr. Arbitrator,
yes.
This representation proposed that each rebuttal must be followed by each pleading. I mean, procedural issues and then rebuttal and rebuttal for procedural issues, and for the merits pleading, and then rebuttal and rebuttal for the merits issues.
Okay. On the appellant side, do you agree with this approach?
I think given the content of our hearing today, I would advise that we have the rebuttal all at the end, so the entire timeline of events is taken into account.
So one rebuttal for all issues. Is my understanding correct? Okay.
Yes.
So then again, we will need to make a decision on this. Again, similarly to the previous one, it seems to me that for procedural efficiency and freshness of mind, it seems more appropriate to have a rebuttal per each section, i.e. have 2 very short rebuttals. Turning to Markus and Pedro, is there an objection at your end to this approach?
No objections, Mr. Chairman.
No objections from my side also, Chairman.
Okay. So we will proceed accordingly. The respondent will start first on jurisdictional objections, then we will hear the appellant, then we will have very short rebuttals before moving to the merits and inverting the order of the pleadings. That is the procedural decision of this panel. And without further ado, we give the floor now immediately to the respondent.
Thank you, Mr. President. Thank you, Mr. President. Good morning from Argentina, members of the tribunal. My name is Agustina Zapata, and I will present the procedural issues of the present proceedings. Members of the tribunal, the whole sports community needs to fight against corruption with intensity. Just as the panel said in the Sundance cases, corruption must be cleaned up because it affects the sport's credibility. In the present case, we are dealing with an appellant who came to this tribunal late, who is trying to remove arbitrators with not valid basis, and who wants to delete evidence because it doesn't suit him. We are dealing with an appellant that only brings dirt. During the next minutes, I will present 3 procedural issues. First, that the appeal submitted before CAS is inadmissible. Second, that the arbitrators Madame Umaima and Mr. Bax must not be disqualified. And third, that the evidence used during the FIFA proceedings is admissible evidence. Moving now to my first submission regarding the admissibility of the appeal submitted before CAS is not admissible because appellant didn't fulfill with the proper time to appeal. According to the Article 58.1 of the FIFA statutes, an appeal must be lodged before CAS within 21 days from the receipt of the final decision. In this sense, according to the Article 82 of the FIFA Code of Ethics, decisions taken by the adjudicatory chamber are final, only subject to appeal before CAS. You will hear from appellant maybe that the time should start to count from the appeal decision. Maybe you will hear that they will base its position in the theory of the own acts or estoppel. However, members of the tribunal, this theory of estoppel is incorrect. It cannot be applicable in the present proceedings. The theory of the own acts or estoppel arises when one party makes a statement that makes to the other believe something and created legitimate expectations in the other party. In the present proceedings, Mr. Oliverato could have never had legitimate expectations for FIFA to rule against its own regulations. Mr. Oliverato could have never had legitimate expectations. He could have never expected that FIFA would accept an appeal in the appeal committee, since appellant, it's an official bounded, but according to the Article 8 of the FIFA statutes, it's an official bounded by the FIFA regulations, and he is supposed, and he has the duty to know the regulations. He should have known that the decision taken by the adjudicatory chamber was final. Having said that, since appellant received such decision on 31st July of 2020, and he decided to appeal to the appeal committee, even though he had to go to CAS, he missed the proper time to appeal. He appealed before CAS on April 20 of 2021, more than 200 days late. Therefore, as appellant didn't submit the appeal in the proper time, the appeal submitted before CAS must be considered inadmissible since didn't fulfill with the time stated in the FIFA statutes. Moving now to my second submission regarding the challenge of the arbitrators. You members of the tribunal, you might will hear from opposing counsel that there are legitimate doubts regarding the independence of Madame Umaima and the impartiality of Mr. Bax. However, there are no legitimate doubts.
Counsel, I'm sorry to interrupt you. I'm really sorry. But before you pass on to the second issue regarding the arbitrator's challenge, I would just like to raise a question regarding what you said for the admissibility of the appeal. It's as you know, in the last page of the adjudicatory chamber decision, there's a sentence that invites the party to challenge this decision to the CAS. I just want your comment on that, please.
Mr. Arbitrator, I think that you are referring to the legal action, aren't you?
Sorry.
Are you referring to the legal action of the appeal committee decision?
Yeah, it's in the exhibits, the decision from the adjudicatory chamber decision in the final page. Yeah, legal action. There's a chapter legal action. Just a comment
awesome.
on that,
Mr. Arbitrator, we are not challenging the jurisdiction of the present tribunal, but the admissibility. However, the legal action cannot be understood as an offer to arbitrate, since the appeal committee is not allowed to modify the FIFA statutes. The appeal committee has not the power to modify what is stated in the statutes and the other regulations. The only who can modify the regulations is the Congress, according to the Article 29 of the FIFA statutes. To support this position, I can address a case that it is the case 456 of the Swiss Federal Tribunal of 2009, in which the Swiss Federal Tribunal annulled the decision of CAS because CAS has understood that they have jurisdiction for a letter sent by one official of the federation to an athlete, in which they stated that they had the possibility to access to CAS. However, the Swiss Federal Tribunal held that kind of communications cannot be understood as an offer to arbitrate. Therefore, as the appeal committee cannot modify the FIFA statutes, it cannot be understood as an offer to arbitrate in the time that it is established there. Moving now to
okay, I'm pleased with the answer. Thank you. You may proceed.
Moving now to the challenge of the arbitrators. Regarding the challenge of Madame Umaima, you might will hear from opposing counsel that there are legitimate doubts about her independence for two main situations: for having been appointed several times by FIFA and for having joined in her law firm, a former member of FIFA in-house counsel. Regarding the several appointments, the IBA guidelines recognize that it is the custom and practice in sports arbitration to frequently appoint the same arbitrator. Also, according to Estelle de la Roche-Foucault, several appointments in sports arbitration are not a conflicting situation for the small pool of arbitrators that we have in sports arbitration. An example of these are the cases of the arbitrators Mr. Gustavo Abreu, Juan José Pinto, and also Massimo Coccia. All of them were appointed more than 9 times by FIFA during the last 3 years, and no conflict of interest arose from these cases. No award was annulled, and no arbitrator was removed. Additionally, according to the exhibit number 8, Madame Umaima participated in 4 proceedings where FIFA was a party as a president of the tribunal, sole arbitrator, and co-arbitrator. It means that at least 2 of these 4 appointments were made by the president of the division of ICAS or by the parties by common agreement, and not directly by FIFA. Additionally, all the appointments together were confirmed by ICAS, who considered that there was no conflict of interest regarding Madame Umaima. Now, regarding the fact that the former member of FIFA in-house counsel joined her law firm, according to Rigozzi, The criteria of independence is only effective ad personam, and it could not be extended to the persons where the arbitrator works. Additionally, according to the clarification 27, the former member of FIFA in-house council is going to work with Madame Umaima and not with the partner of Madame Umaima and not with her, and also that he doesn't even know about the proceedings before Mr. Atom in FIFA. Moving now to the appointment of Mr. Underbags, you might will hear from opposing counsel that there are legitimate doubts about his impartiality. Opposing counsel, according to the skeleton presented and the list of authorities, they will base its position in his authority number 9, the Sanyan case. However, that Sanyan case cannot be applicable and cannot be compared with the situation of Mr. Underbags in the present proceedings. In the Sanyan case, the arbitrator made several aggressive and racist comments during the proceedings. In the present case, Mr. Underbags just made one comment on LinkedIn before the hearings, and also he made that comment because of his position of an NGO. Mr. Arbitrator, Mr. President, I see that my time is almost to elapse. Can I ask you for extra time just to finish my presentation?
Yes, you can, because the panel will not account for your answering the questions of Mr. Garcia Correia.
Thank you. So, as the Sanyan case cannot be compared from the present case, additionally, what this tribunal should bear in mind regarding the comment of Mr. Underbags is that the comment was not against Mr. Atom, was not related to the present proceedings, and was not aggressive in any way. Therefore, the challenge of Mr. Bags must be rejected since the arbitrator actions cannot show the bias of the arbitrator. Moving on to the admissibility of the evidence, you might will hear from opposing counsel that the evidence used during the FIFA proceedings is inadmissible, relying in the Telegram chats and the whistleblower statement. Regarding the Telegram chats, they are admissible evidence since, according to the Manchester City case, in which the tribunal analyzed the Article 152 of the Swiss Procedural Code, illegally obtained evidence is not inadmissible per se, because there must be a balance of interest in finding the truth and the rights that are infringed. In the present case, we had a lot of interest since we're attacking of the corruption in the bidding process of the World Cup, Football World Cup, the most important and one of the biggest events of sports in the world. Therefore, as the interest in finding the truth are higher than the rights that are going to be infringed, illegally obtained evidence shall be considered admissible. Regarding now the whistleblower statement, it shall be considered admissible since, according two important precedents to this tribunal bear in mind are the precedents of the Marco Polo Terra Teixeira and also the Marco Polo de Nero and Ricardo Terra Teixeira, in which the tribunal considered that whistleblower statements that came from criminal proceedings shall be considered admissible evidence since they are documentary evidence, as in the present case. In the present case, this whistleblower statement came from a criminal judge of Harlan. Therefore, they must be considered as admissible evidence since appellant would have the opportunity to ample comment such evidence. To finish, members of the tribunal, this representation wants to emphasize once again that it is a case of corruption. This is a case that strikes at the heart of sports and members of the tribunal. This is a case in which corruption can be cleaned up. Therefore, this representation respectfully requests this tribunal to hold that the appeal submitted before CAS is inadmissible, that the appointed arbitrators, Madame Umaima and Mr. Bax, must not be disqualified, and that the evidence used during the FIFA proceedings is admissible evidence. If the tribunal has no further questions, this concludes my presentation. Thank you.
Thank you very much. I have no question at this stage. Are there questions from my fellow co-panelists?
Mr. Chairman, I have planned a question, but I would prefer to present that to both of the parties at the same time. So later on, thank you.
Understood. Thank you very much.
Yes, I have one further question, but I wish to listen first the pleadings from the appellant.
Okay. Thank you very much. I now give the floor to the appellant on those distinct issues, please. Thank you very much.
Members of the panel, you've heard some very impassioned pleas from my colleague, but now please allow me to guide the panel and apply a bit of logic and reason to this hearing. In relation to the issue 1, whether or not the CAS tribunal has jurisdiction to hear the proceedings today, we simply submit that the appeal is admissible. In accordance with Article 47 of the CAS Code, the statement of appeal was filed within 21 days of the receipt of the FIFA appeal decision, with reference to Article 57, subsection 1 of the FIFA statutes, which is number 1 in our bundle. And accordingly, we would submit that the CAS shall apply the FIFA statutes, FIFA regulations, and the Code of Ethics, and Swiss law shall apply on a subsidiary basis. They also raise issues regarding not having, with the appeal itself not being admissible. And I wish to apply this train of thought as follows. In Article 82 of the FIFA Code of Ethics, they referred that the decisions of the adjudicatory tribunal are final and should be appealed directly to CAS. But I would like to turn your attention to Article 81 of the Code of Ethics, which provides that decisions concerning Article 29 can be appealed to the appeal committee before going to CAS. And Article 29 in that code shows that the facts of our case involve the manipulation of a competition, of which the World Cup is clearly one of those. And with that background, it was perfectly acceptable to go to the appeal committee and then to go to CAS. And furthermore, by doing so, we can also be seen on the appellant's behalf, they have exhausted all legal internal remedies under the CAS code. But furthermore, once more to the FIFA Code of Ethics, with Article 58, subsection 3, dispute shall be taken to an independent and duly constituted arbitration tribunal, recognised under the rules of the association or CAS. Now, the appeal committee may well be independent, but it's not a constituted arbitral tribunal. So therefore, it is warranted to bring this to CAS. Moving to the second issue, with the challenges against the arbitrators in relation to Mr. Vax and Professor Imaima, we simply submit the
counsel, sorry to interrupt, just to be fair, the interruption that I made to the counsel from the respondent, and sorry to interrupt. But I'll just make questions regarding this because it's a very linear question regarding the jurisdiction. But are you aware that which version from the Code of Ethics of FIFA are you referring to? 2018, I guess.
It would be the one in our bundle, Mr.
Okay, I think 2018, because the thing is if you are aware that the version from 2012, it referred as a final decision, the decision from the appeal committee, and there was an amendment to this code, and now this version from 2018 refers to the adjudicatory chamber, not anymore to the appeal committee. Do you have any comment on that, please? Thank you.
When an amendment like that happens, it does create some uncertainty, and I think you're right to point that out. But actually, with that answer, I would like to draw the answer from number 1 from the respondents bundle, which is CAS 2010 A2193 and Calcio against Deportivo, with reference to paragraph 10, because I think it applies to Mr. Atten. And it reads that if furthermore results from case law that the party which has no previous procedural experience will be deemed to have been more easily misled. And if there is an issue here, it should not be to the disadvantage of Mr. Atten, given that these are his first proceedings and he's otherwise had an outstanding, clean record as an official within FIFA.
Okay, thank you.
Thank you. With that background, we turn to the issues of the arbitrators. And I wish to start by saying the grounds for the challenges of both arbitrators are in relation to breaches of Article 33 of the CAS Code, and that's reference number 4 in our bundle. You don't have to go to it because I'll read the important bit, which reads as follows. Every arbitrator shall be and remain impartial and independent of all the parties, and shall immediately disclose any circumstances which may affect his or her independence with respect to the parties. And our challenge has been submitted within the 7-day period as stated within Article 34 of the CAS Code. But we also wish to state that by objecting to 2 of the arbitrators, the appellant has not freely waived his rights to a free trial under Article 6, subsection 1 of the ECHR. And it is well established that the application of ECHR is indirectly applicable in CAS proceedings, as shown in number 20 of our bundle, Adamo against FIFA, with reference to paragraph 66. But with this background, each panel's members' violation will be addressed in turn. The reason for Mr. Vax's disqualification stems from the LinkedIn post on the 20th of November 2021, which was discovered by the appellant 3 days before this hearing. And the post criticises the COVID-19 anti-vaccination movement, a cause which our client has a vested interest in. And we obviously submit this is a breach of R33 CAS Code and Article 6 ECHR. But I'd like to turn your attention to number 13 on our bundle, which is the IBA guidelines, sections 2B and 2C. And that provides an arbitrator must resign if after their appointment relevant facts arise which infer justifiable doubts as to the arbitrator's impartiality or independence. With reference to the SAM bundle, Exhibit 7, page 14, I wish to read to you Mr. Vax's opinion on the anti-vaccination movement. It's simple. People who oppose vaccine mandates pose a danger to public health. This free rider attitude is incredibly unfortunate and egotistic. These are uneducated people who think only about themselves. Now, the appellant submits that the content of Exhibit 7 strongly infers an unconscious bias of Mr. Vax towards the appellant. And the implications of a bias arbitrator were addressed by the Federal Supreme Court in Yang against WADA, which is number 9 in our bundle. Now, in Yang, the CAS award was annulled after it was discovered that the president of the panel issued 3 tweets, which were held to be a breach of impartiality. And the tweets were of a racist nature against the people of China, where the appellant, a Chinese swimmer, was from. And I know the respondents had different opinions to this, stating that it was a hammer blow of partiality. But in our case, the court mentioned that merely the impression of partiality will justify the disqualification of a judge. Now, a similar issue arose in Mutu and Pechstein against Switzerland, which is number 11 on our bundle. But Mutu's challenge against the president of the panel there was rejected due to a lack of evidence. But this is distinguished from our case, with Mr. Vax's LinkedIn post clearly demonstrating this breach of impartiality. And therefore, there is a strong possibility, we submit, of further proceedings at the Swiss Federal Tribunal if Mr. Vax's disqualification is not dealt with at this stage. Therefore, we kindly invite the panel to apply the logic from the Yang case and to consider the wording of Mr. Vax's LinkedIn comment as a clear impression of partiality. In relation to Professor Umaima, turning your attention to the SAM bundle, Exhibit 8, page 15, on the 2nd of March, 2022, Professor Umaima disclosed by email that during the last 3 years, she acted as sole arbitrator, president, and co-arbitrator in 4 arbitral proceedings in which FIFA was a party. This also constitutes R33 CAS Code and a breach of Article 6 ECHR. But additionally, Professor Umaima's actions are within this orange list of activities within the IBA guidelines. Once more back to number 13 of our bundle, this time page 22, sections 3.11 to 3.13. But you see, on 2 occasions, Professor Umaima was appointed by FIFA, which is enough to violate 3.13. But it is also because Professor Umaima did not declare their conflict of interest immediately at the panel that the appellant submits that this conflict of interest threatens the partiality of the panel. Now, conversely, footnote 5 on that page brings in the argument that it is acceptable in sports arbitration to frequently appoint the same arbitrator. And indeed, while the Mutu and Stein against Switzerland case held that the CAS is in general an independent and impartial tribunal, 2 judges dissented from this view, expressing that the structure of the CAS was in fact a violation of Article 6. And with this background, it is reasonable to infer that on some occasions, the panel may simply be misbalanced. And this is clearly the case with Professor Umaima. And in a world of online hearings, it has never been easier to substitute an arbitrator, of which there are 380 in the queue. We appeal to the panel's common sense to remedy this. But Professor Umaima's negligence is also further pronounced when assessed against the procedure of appointing an arbitrator under Article 40.3 of the CAS Code. And the code provides that an arbitrator must complete a form confirming their impartiality and independence, which must then be ratified by the president of the division. And it was at this point precisely where Professor Umaima should have declared their conflict, rather than her belated email 5 days before the hearing. Ultimately, it is for the Challenge Commission to remove an arbitrator and to arrange a replacement arbitrator. But we kindly invite the panel to consider the replacement of the arbitrators as central to ensuring the decision of this hearing is not later annulled by another court. Doing so not only save future court fees, but also uphold the reputation of the CAS as an independent tribunal. Turning to issue 3 in the witness statement, used to support the FIFA appeal decision. When anonymous witness statements are used, the right to be heard, which is guaranteed by Article 6 ECHR and 29.2 of the Swiss Code, Swiss Constitution, is affected. To mitigate this, a body of ECHR case law provides that the use of anonymous witnesses may be admissible subject to strict conditions. And these strict conditions are outlined in number 18 of our bundle, paragraph 31. In the interest of time, rather than listing all 3, then applying them, I will just apply them straight from the off. But we submit that these 3 criteria have not been met. In regards to the first limb, the witness was only heard by a Hardlandian judge due to an abstract fear of reprisal. And paragraph 29 of the same authority, number 18, provides that an abstract fear is not enough to justify the full anonymity of a witness. In fact, in that same case, full anonymity was denied because there's no concrete evidence of threats which could be established. In regards to the second limb, on our facts, the witness was neither questioned by the FIFA Appeal Committee, nor were any checks made on the reliability of these statements. And finally, there was no cross-examination by any means, less alone audiovisual or anything which would protect the identity of said witness. Altogether, the witness should not have had full anonymity. They should have been cross-examined, and the reliability of their statement should have been checked. Once more to number 18 on the bundle, paragraph 30, the panel were mindful that the Swiss Federal Tribunal also stressed that the ECHR and its own jurisprudence impose that a tribunal's decision should not be based solely or to a decisive extent on an anonymous witness statement. For the reasons mentioned, such mismanaged evidence is of little use to the CAS.
Please conclude, Mr. Kilgallon.
I'm concluding now. Instead, the respondent's main evidence is a screenshot of a Telegram message alleged to originate from the appellant's mobile phone. Ultimately, the CAS has ultimate discretion regarding proof. We can't prove the Telegram was a forgery, but in the same way that the respondents can't prove that it was real. But ultimately, the inclusion of and reliance of such evidence poses greater risks to the integrity of CAS procedure than any perceived risk to the integrity of football. Members of the panel, if I can't assist you any further, I will hand over to my colleague, Mr. Kaluza.
Thank you very much. If anyone, it's up to the panel to hand over to the respondent for a short rebuttal, unless, and I'm turning here to my co-panelists, unless they wish to put their question now to the parties. Markus?
Mr. Chairman, I suggest that we hear the rebuttals first, and then if I still have a valid question, then I will pose that. Thank you.
Thank you. That seems reasonable. Pedro?
Likewise, same from my side.
All right. So turning back to the respondent, is Ms. Zapata, will you be conducting the rebuttal?
Yes. Okay.
Oh, Okay, so please go ahead. You have 90 seconds. Thank you very much.
Thank you, Mr. President. Members of the tribunal, maybe appellant wrongly appealed before CAS and didn't fulfill with the proper time because doesn't know which are the applicable regulations at that time. Opposing counsel mentioned an exception of the Article 81 of the FIFA Code of Ethics. However, that exception is in the FIFA Code of Ethics in its version of 2018. And the applicable regulation at that proceedings is the FIFA Code of Ethics of 2019. And no exception to appeal before the appeal committee exists in that code. The decisions taken by the adjudicatory chamber only can be subject to appeal before CAS. Also, additionally, opposing counsel mentioned the case of Club Olimpia Deportivo, and in that case, opposing counsel said that Mr. Atom has no experience, but and that for that reason he can commit a mistake. But appellant is not taking into account that Mr. Atom is bounded by the FIFA regulations for 13 years. For 13 years. Also, in that case, says that the protection to the good faith of a party ceases when the mistake can be cured simply checking the regulations at that time. Thank you.
Thank you very much, and thank you for sticking with the time limits. Mr. Kilgallon, the floor is yours.
I'm very glad the respondent has made mention of the FIFA statutes, because one of them states in Article 3 that FIFA is committed to recognising human rights. And of course, Article 6 ECHR is a recognised human right. And what we've seen from the new arising evidence of the arbitrators, that this threats Mr. Atom's right to be heard. So all these issues aside, even if this is appealed now, there's enough new evidence that this is going to be brought or restarted by the investigatory chamber under Article 62 of the FIFA Code of Ethics, because new elements or evidence has arisen. And with that background, it is perfectly acceptable, and it has been on the past, that errors made by a party on the first time, on the first principle, can simply be allowed. And with that background, I simply submit the respondents are engaging in time distraction tactics and simply kicking the can down the road, because this hearing is going to happen one way or another. And there ends my rebuttal.
Thank you very much. Can you repeat your last point? I'm not sure I understood your last comment, please.
Of course. So in issue 2, we've mentioned that Mr. Vax and Professor Imaima we've gathered new evidence on their breaches of impartiality. And it's important that that gets recognized in these proceedings, because it hasn't been recognized in prior times. But we also wish to submit, stemming from that in the previous appeal committees and ethics chambers, Article 6 and his right to be heard hasn't been satisfied. And we now have simply more conclusive evidence of that. And I think the investigatory chamber will find that satisfactory to resume the investigations, which will simply bring this back in cycle. And I think with that, it makes sense to hear this now, as opposed to causing further delay and further legal costs for both parties involved.
Thank you very much. Now, turning to my co-panelists, are there questions that they wish to raise now with, I understand, both parties? In which case, would you kindly indicate which of the two parties you wish to hear first on your questions, please? Markus.
Thank you, Mr. Chairman. So I would like to first hear from the respondent and then from the appellant about the challenge on Mr. Vax. So I would like both parties to briefly elaborate on whether or not the different lists, so red, orange, and green list of the IBA guidelines on conflicts of interest in international arbitration support the challenge or not, and what are the grounds for such position? Thank you.
Mr. Arbitrator, regarding your question, there is no situation in the IBA guidelines that could be compared to the challenge of Mr. Andrebax. No situation, nor in the red list, nor in the orange list. The challenge has no place in the IBA guidelines. The challenge of Appellant has no valid basis. He is trying just to sustain his position of the Sanyan case that it is not applicable in the present case.
Thank you. And the appellant, please.
In the IBA guidelines, it's important to recognize section 2b, where it says the arbitrator must simply resign when there's new evidence or knowledge which arises, which gives justifiable doubts as to the arbitrator's impartiality or independence. And it was this that was found persuasive in Yang when they aligned those tweets to give an impression of said partiality. And it is with that basis that we would find persuasive and applies. And I know there's points about the tweets being far more aggressive than what was mentioned in the LinkedIn post by Mr. Vax, but the principle remains the same. It was a strong topic on a topical issue which had direct relevance to the appellant in question.
Thank you.
Thank you, Markus. Pedro, do you have a question at this stage?
Yes, please. If you allow me, I would raise the question now.
Of course.
Thank you. So the first question, and respecting the order of the pleadings, will go to the respondent. And regarding the validity of the witness statement of the whistleblower, because in my mind there is a red flag that keeps waving in front of my eyes, and that's one fact that was given by the elements that we have from this case, is that Ireland, where the criminal proceedings were pending, is not a party to the European Convention on Human Rights. And having this in mind, I would ask you I would put the following question on the table. Would you agree that FIFA could have accepted the whistleblower's testimony as valid evidence only upon the condition that all the necessary measures and steps were taken in order to assure that the Ireland judge, when obtaining such testimony, as well as validating it within the criminal proceedings, had respected the rights that are enshrined in such convention? And I refer to the Article 6, paragraph 3, letter D of the European Convention on Human Rights. And of course, also the case law that I think one of the teams referred to, the case, the Podeba Alexander Zdravetsky versus UEFA. But the thing is, if FIFA is taking as good evidence the statements of a whistleblower that was not cross-examined from a criminal proceedings that took place in a country that is not party to the European Convention on Human Rights, shouldn't we have the warranty that FIFA took all the necessary measures and steps to assure that these rights was observed and these principles to the right to a fair trial were also respected? That is my question to the respondent.
Mr. Arbitrator, despite that Ireland is not part of the European Convention of Human Rights, does not mean that the Ireland judge didn't cross-examine the witness. As President stated, there is no need to cross-examination before FIFA or before the CAS, since the whistleblower statement shall be considered as documentary evidence, and the right to be heard is not going to be violated, since the parties have ample powers to comment such evidence. So it means that the right to be heard is going to be respected in this sense.
Okay, thank you. I don't know if I could just make a question to the appellant.
Oh, are you asking the same question to me? Sorry.
No. I'm asking the chairman if I can raise a question, a different question to the appellant.
Yes, of
regarding the
course.
procedural.
But in the interest of time, I think we should move on. So if both the question and the answer could be brief, that would be fantastic. Thank you.
Okay. Thank you, Mr. Chairman. So the thing is regarding the evidence. I don't know if you have any position. I heard that you just made a brief reference to the Exhibit 5, the Telegram messages, and I didn't quite get your position on that. And so, do you think that this piece of evidence should be admitted and unconditionally valued by this court? I ask.
On the facts as it is now, we would submit that the evidence isn't admissible, but of course there are multiple criteria which need to be satisfied for your consideration to accept this. And one case which I hadn't mentioned before, but is in our bundle, is the case of Keramudin. And I think that provides useful guidance on this, because in that case, all the three criteria where the witnesses were brought over and identified, then they were made anonymous through audiovisual cross-examination, that seemed to satisfy evidence pleadings with people from Afghanistan. And on that basis, if it's possible to know the identity, so statements can actually be genuinely verified, then there might be room to accept the evidence. But currently, as it is, that hasn't been satisfied.
Okay, thank you. No further questions.
Okay, thank you very much. I think this concludes the preliminary issues on jurisdiction and admissibility. And I now, without further ado, in the interest of time, immediately ask Mr. Kaluza, I guess, to make his oral arguments on behalf of the appellant with respect to the merits. Mr. Kaluza, the floor is yours. Thank you.
Thank you, Mr. President. Members of the tribunal, as formally introduced, I am Mr. Kaluza, and I will submit on issue 4 that the alleged breach of Article 27 has not been proven to comfortable satisfaction, and issue 5 that imposed sanctions were grossly disproportionate, as stated in the skeleton argument on behalf of the appellant. Moving to issue 4, it is a well-established principle that it is for the respondent to prove that the appellant committed the acts of bribery to the comfortable satisfaction of the panel, having in mind the seriousness of the allegation made. And this authority comes from the case of Teixeira, number 5 in the bundle, paragraph 88. Therefore, the respondents needs to prove 4 requirements of Article 27, paragraph 1 of FIFA Code of Ethics, that they have been met. And these 4 requirements are that the person is bound by the code, that the person has received an advantage, thirdly, that this advantage was personal or undue, and finally, that this advantage was obtained in order to obtain or retain business or any other improper advantage. Members of the panel, while there is no dispute that the appellant is bound by the code, the respondent cannot prove with comfortable satisfaction that the appellant accepted any undue advantage in exchange for voting for Hardland in the World Cup bid. This is due to the lack of any direct evidence that could reasonably constitute basis for such allegation. If I can move to the main evidence in this matter, the Exhibit 4, which is the statement of the unknown person, which refers to the meeting between Mr. Kaiser and 2 foreign individuals that took place on the 28th of July 2016. The witness account is dated 5th December 2017, 17 months after the alleged meeting. If I can ask members of this tribunal, how much would you remember from a meeting from December 2020? Not your meeting, but simply a meeting that you have witnessed in the background. I suspect you might struggle to come with any detailed recollection. Yet in this case, the respondent decided that the appellant breach of Article 27 is proven by this piece of evidence, the Exhibit 4, this such long-awaited recollection. If I can refer members of the tribunal to paragraph 13 of the statement, the very last sentence, this unknown person stated, "I could not identify these individuals as I was facing their backs." There's no evidence even pointing to Mr. Atom directly. Following from that, the Exhibit 4, and we learn from the Exhibit 4 that the witness heard fragments of conversations where Mr. Kaiser is alleged to have rewarded these two individuals by modest token of appreciation. It is submitted that this disjoint evidence is far from conclusive to say that there has been a breach of Article 27. And I would like to compare the evidence in this case from evidences from other cases in this tribunal. For example, the case of Adamo against FIFA as number 20 in the list of authority, or the case of Fusimoli against FIFA, number 12 in the authority list, where the case against the defendants were based on pages of transcripts from recorded conversations that were also verified by two undercover journalists. In this matter, however, we are presented with a mere few pages of statement by an unknown witness, littered with irrelevant statements that are not substantiated with any additional evidence. For example, phrases such, "Please don't touch your wallet," is more than reasonable saying in a social situation. Additionally, Mr. Kaiser remarks about a TV rights deal, which was under influence of alcohol, cannot be treated seriously as an offer or a bribe. There is need for some additional evidence which is absent in this matter. And again, if I can refer to the Teixeira case, number 5 in the bundle, in this case, there were also alleged bribes in relation to TV deals. However, this accusation was proven by several evidence, or several testimonies by witnesses, specific information from the contracts, and also recordings of phone conversations and emails. All of the aforementioned pieces of evidence were successful in proving bribery with comfortable satisfaction, simply because it created the whole picture of what has actually happened. In the present case, however, we are presented with pieces of unrelated and unsupported evidence that doesn't really explain the situation as a whole. The tribunal is invited to follow the approach that can be found in the case of Bin Haman against FIFA, number 6 on the list of authorities, where an inconsistent witness report was disregarded and considered as not really helpful in explanation of what may or may not have happened in the situation of the bribery, paragraph 180. Additionally, the CAS tribunal in this particular case agreed that there are multiple plausible scenarios of what could have happened if there is absence of direct evidence and the case is built on circumstantial evidence. Paragraph 194 of this case. And it is submitted that it's exactly the issue here, that the respondent's case is like a Swiss cheese. It's just full of holes and doesn't tell a whole picture. Their case is based on weak circumstantial evidence and does not prove to a comfortable satisfaction that watches and TV right deals were provided to Mr. Atom for exchange of his vote in the election for World Cup bid. Therefore, the breach of Article 27 cannot be proven to a comfortable satisfaction, and we ask the tribunal to dismiss issue 4. Should the tribunal disagree with my submissions, I shall move to issue 5 to say that the sanctions imposed by FIFA in this matter were grossly disproportionate. To prove this point, I shall refer to 2 cases, previous cases. Firstly, to the case of Adamo already mentioned, number 20 in the list of authorities. In this particular case, the defendant was offered $800,000 US as a bribe, yet he was only sanctioned by 3 years ban and 10,000 Swiss francs. Moving to the second case, the case of Platini, number 16 on the bundle. Mr. Platini, a very prominent figure of FIFA and UEFA, was accepted the additional payment of 2 million Swiss francs. And the fine in this case was firstly 80,000 Swiss francs and 8-year ban, which was later reduced to 60,000 and 4-year ban. In this matter, Mr. Atom was sanctioned with 15 years and 50,000 Swiss francs. Members of the tribunal, looking at sanctions in this matter as compared with 2 cases I just quoted, where the alleged bribes were 20 or 40 times more than it is the case here, how can one say that the sanctions that are almost twice high are proportionate or reasonable? It is submitted they are not. Additionally, for the appellant age 40, combination of 15 years ban and 50,000 Swiss francs fine pose an excessive limitation of his economic freedom and is contrary to public policy. And that follows from the case of Zaragoza, number 14, and the list of authorities, paragraph 435. Moving to the last point I shall make in my submissions, the tribunal is invited to consider mitigating circumstances that FIFA has failed to recognize in their decisions. And Article 9 and 10 of the FIFA Code of Ethics invites recognition of such mitigating circumstances. And it is submitted that for 10 years, Mr. Atom has served the FIFA with a clean record and with no prior offenses or repeated breaches. Additionally, should the tribunal recognize that the bribery has been made and undue advantage received, I shall direct your attention to the fact that Mr. Atom actually paid back the significant amount of money to Mr. Kaiser, which also should be taken into account while deciding on the sanctions. Therefore, if I can propose a new sanction, should the tribunal recognize the breach of Article 27, the appellant asks for a 3-year ban and 20,000 Swiss francs, as that would be more reasonable. With that being said, the appellant respectfully invites the tribunal for the following reliefs, as stated by my colleague, that there is jurisdiction to hear the appeal, that the challenges against Professor Omaima and Mr. Vax are upheld, that the anonymous witness and telegram evidence should be disregarded, and in the event the panel does accept the tainted evidence, we submit that the evidence does not prove the respondent's case to the required standard of the comfortable satisfaction. And finally, should the tribunal disagree with issue 4, it is submitted that the sanctions are disproportionate and should be reduced to 3 years ban and 20,000 Swiss francs. This concludes my submission on behalf of the appellant. Thank you.
Thank you very much. Unless there are pressing questions, and I'm just looking at Markus and Pedro, I suggest we move on immediately to the oral arguments of respondents. Ms. Beyer, the floor is yours.
Thank you, Mr. President. Members of the tribunal, as it was mentioned before, my name is Marianne Beyer, and I'm going to address the merits of this case on behalf of FIFA, the respondent. And to do so, let me show you a different review of how this match is really going. Because the appellant does not only have a questionable tragedy during this proceeding, but he also bases his argument on a fictitious view of his own actions.
I'm
During
sorry,
my presentation,
a
questionable strategy on these proceedings. Yes.
Okay, thank you very much.
During my presentation, I will reveal the distorted story that Mr. Atom is actually trying to convince this tribunal with no more and no less than the facts and the evidence that the appellant wants to ignore. For this reason, I'll make the following 2 submissions, mirroring what opposing counsel stated. First, that the appellant breached the Article 27 of the FIFA Code of Ethics, and second, that the sanctions are proportionate. To come to the first submission, in order to this tribunal to fully understand how the commission of bribery is committed, we should do it in light of the Ricardo Teixeira versus FIFA case, where the CAS panel analyzed the bribery commission under the light of the FIFA Code of Ethics on its Article 27, and determined that there must be 4 accumulative elements to be satisfied. In this present case, they all have been satisfied, and according with the facts and the evidence provided by these parties. Firstly, as the appellant mentioned, this person must be bound by the FIFA Code of Ethics, which is undisputed by the parties, because Mr. Atom is the president of the Football Federation of Thailand. Secondly, this person must accept and receive an advantage. And in order to this tribunal to understand this specific element, we should address this advantage as the interpretation of the case made on the Amos and Marius versus FIFA case, which the appellant have actually mentioned. This is that the case actually interpreted that the advantage of bribery can take literally any form. And in this present case, within the record, the facts and the evidence that is actually reliable against what the opposing counsel said, we can conclude that Mr. Atom need not only received a non-inclusive business trip to Bigland, but also he received several other benefits and gifts. And these are according to the reliable witness statement, because this whistleblower actually is reliable because firstly, he did recognize the person as they were talking they're talking about Tinyland. Second, because this person was actually talking about Kaiser. He was in the Michelin restaurant, they were both in there. And we can always remember how a person was actually considered in that present moment. In this case, the appellant actually received several other advantages during this trip. Firstly, that free massages, the free room service, a business trip in which he received a shiny, luxurious watch, and even he arranged a match that he wasn't supposed to. Because of these, members of the tribunal, Mr. Artom actually received several advantages under the interpretation of the case made. Secondly, the other element is that these advantages shall be personal or undue, which truly are characterizing the bribe of this misconduct. Because, members of the tribunal, firstly, Mr. Artom received a personal advantage that Mr. Kaiser gave to Mr. Artom, several things that he actually enjoyed himself. On the other hand, they were undue because they didn't have any contractual legal basis. And actually, these two requirements are actually reinforced by the facts that Mr. Artom made a reimbursement of these fully amounted price of these all benefits that he received. This is because he felt regret, and he was regret of having accepted and received all these things. Now, the fourth and last element of bribery is the quid pro quo, which has to be understood as an agreement context between the parties in order to have reciprocal benefits. Now, members of the tribunal, it is true that given that these bribery schemes, the parties will do everything to hide their wrongdoings. So there is no need to actually have an express agreement. However, in this present case, we have clear evidence that Mr. Kaiser incited and seduced Mr. Artom in order to have his unlawful vote in this World Cup allocation bidding process. And this is actually have seen in the Exhibit 4, which is actually reliable because of the things that I have mentioned, in which Mr. Artom actually commented to Mr. Kaiser the following line. Judging what we have seen all these days here in Bigland, this will be a workout for the ages, which is actually reinforced by the fact that Mr. Artom made a comment to Mr. Lenders on the Telegram messages that are admissible. And this is, after all they did for us, the least we can do is vote for them. Which Mr. Lenders replied, yep, agreed. We cannot roll back now. It seems that Mr. Kaiser actually incited and provoked Mr. Artom to sell his vote in the World Cup bidding process. And Mr. Artom actually complied with this scheme, and he agreed that he was receiving all these benefits for only these purposes. Given that the four elements of bribery had been satisfied, Mr. Artom is guilty of committing bribery. Now, turning to the second submission, and contrary to what the opposing counsel stated, the sanctions imposed to Mr. Artom, which are a 15 US ban and a 50,000 Swiss francs, are actually proportionate because of the several reasons. The first one is because there are several aggravating circumstances to consider in this case. According to the Article 9 of the FIFA Code of Ethics, when imposing a sanction, all relevant factors might be considered. This means the presence of aggravating circumstances, which are present, and they have been analyzed in the case of Ramos and Marius versus FIFA, which the opposing counsel will mention. And these are, firstly, the harm to football, the harm to FIFA's reputation, and the harm to World Cup and its bidding process. Secondly, the fact that Mr. Atom had a special responsibility to comply with, because he's a president of the Football Federation. Thirdly, because there was a real materialized bribery scheme where Mr. Atom sold his vote for the World Cup bidding process. The second reason why this tribunal should consider the sanctions proportionate is because of the comparison with other cases. Because contrary to what the opposing counsel stated, the case of Amos Amadeus versus FIFA cannot be compared with this one, according to the analysis that the CAS panel made on the cases of Marco Polo De Niro or Westin Taki versus FIFA. In these cases, the appellants also argumented that those cases were comparable to the Amos Amadeus one, and the CAS determined that they were not because they were not useful, as the sanctions imposed to them were actually mild, and the CAS were actually acknowledging these facts. The CAS said, yes, these are mild. Secondly, because they cannot be used, as the CAS were prevented in order to put severe sanctions. The last point of this argument, the last point of this submission, is that the sanctions imposed to Mr. Atom do not, in any case, violate the human rights that the opposing counsel mentioned. This is because the appellant is actually arguing that this case is comparable to the Swiss Federal Tribunal case. However, this tribunal should take into account. Mr. President, I see my time is running short. Should I ask the tribunal for more time in order to conclude my presentation?
If you could be kind enough to conclude within as short possible time, that would be much appreciated. You have another 1 minute left.
Okay, thank you. The opposing counsel mentioned this case, which this tribunal should not consider, because that fact actually differs totally from this one, as it was from a contractual breach for a football player. In this case, we are talking about the severity of bribery, corruption. In that case, this tribunal should consider the case of Yon Fiorel versus FIFA versus RFF, where the CAS panel determined that the unlimited ban, which was imposed in this case to Mr. Atom, did not actually prevent the appellant in order to have economic freedom. For this reason, this tribunal should not reduce the sanctions and not remove the ban for Mr. Atom. Members of the tribunal, we should consider that this case is about corruption. As my co-counsel stated before, corruption strikes at the heart of the sport. And in this case, we can see that the appellant wants to do everything just to have more advantages. In this regard, this representation respectfully requests the tribunal to find Mr. Atom guilty of committing bribery and to uphold the sanctions imposed to him. Thank you.
Thank you very much. May I ask the claimants team, Mr. Kaluza, to give a very short rebuttal of about 1 minute, if that is possible. Thank you very much.
Yes, of course. Firstly, very briefly, the recognition of Mr. Kaiser by a witness is not the same as recognition of Mr. Atom, so it's just wrong to say that Mr. Atom was recognized by the witness. Secondly, my opponent referred to the fact that bribery should be a secret rather than in bright light of the day. So my question is, why would anyone commit bribery in the most luxurious restaurant in the country? That's rather unreasonable to assume. I will also refer to the Bin Haman case, which says that there are various possible explanations to the back payment made by Mr. Atom. It might have been connected to different matter. We just simply don't know, and there is just no evidence presented. And finally, I shall refer to the argument that the case I have used are not relevant or indeed mild measures. The case of the Platini is highly relevant, and the CAS tribunal and Swiss tribunal actually reduced the sentence in this matter, proving that there were quite harsh measures and they can be compared. Thank you.
Thank you very much. Ms. Beyer, please go ahead.
Yes, thank you. Members of the tribunal, respectfully, I will answer to the opposing counsel. Firstly, there is no need to actually recognize the Mr. Atom or Mr. Lenders, as in this very same conversation, it was mentioned Thailand. So he was aware of this person where. Secondly, bribery does need to have a secret because, of course, the parties will do everything to hide their wrongdoings. And this is actually because they have an agreement that they didn't want to actually reveal to everyone. However, it was revealed. Then the reimbursement, the evidence is actually reliable. And according to what the opposing counsel stated about the case of Platini, this case is also not reliable and not comparable with this one, because in the case of Platini, he was charged for committing the gift and undue advantages. And in this case, we are talking about bribery. These two offenses are totally different, and this tribunal should not consider the application of Platini case. Thank you.
Thank you both very much for sticking to the time limit. Again, I am conscious of time, so are there any extremely pressing questions from my co-arbitrators which can be put within as short time frame as possible? I'm looking at Markus.
Mr. Chairman, no need to present any questions. I have the information that I need to resolve the case.
Thank you very much. Pedro?
The same also. Actually, sorry, Mr. Chairman. Just I can avoid just make one question to respondent regarding the standard of proof. Do you allow me to make this question? I'll try to be brief.
Yes, please. Thank you.
Thank you, Mr. Chairman. So I would just like to raise this question that because FIFA Investigatory Chamber opened the investigations in March 2019, I think they had more than 10 months or something to carry, so they have the opportunity during these 10 months to carry out a complete investigation. And even more, taking advantage of the evidence that was already collected within the Heartland criminal proceedings. So actually, what I would like to raise is that, would you agree that the lack of further evidence, in addition to the fact that those two pieces of evidence that not enjoy enough certainty as to their authenticity, I'm referring to the telegram messages and the whistleblower witness statements. So do you think that there's no sufficient evidence that that was collected that allows the conviction on the basis of the comfortable satisfaction? That's a real demanding standard of proof. So after what I'm saying is after 10 months of investigation and just coming across two pieces of evidence, what I ask is, do you think that we can reach a comfortable satisfaction with these two pieces of evidence? That's my question, please.
Mr. Arbitrator, in fact, this representation thinks and actually support that this tribunal can be comfortably satisfied by the two pieces of evidence. Again, reinforcement, this evidence with the facts and the records of the case, with the other evidence, what do we have, which are the other exhibits? We don't only have these two pieces of evidence. This tribunal should recollect all the evidence and all the facts of this case to actually be comfortably satisfied. With all these pieces together, we can conclude that Mr. Atom was guilty of committing bribery, as the four elements of bribery has been satisfied.
Okay, thank you. No further questions.
Okay, thank you very much. I think this concludes this hearing. I just would like to ask the parties to confirm before the panel deliberates that there are no objections procedurally as to where these hearings have been conducted. So turning to the claimant, any objections to the appellant?
No objections, Mr. President.
Thank you very much. Turning to the respondent, any objections?
No objections, Mr. President. We are satisfied how the hearings went.
Thank you very much. That therefore concludes this hearing. What the panel will do now is go into a separate breakout room to shortly deliberate on your performance, it being clear that there will be, as of now, no hint or decision as to which of the two sides prevailed. You will be informed by the organizing committee in due course. But the purpose of this exercise is just for the panel to deliberate and share views, and then within as short time frame as possible, get back to you with our individual feedback. So please stay tuned. Thank you again, and thank you obviously to the co-panelists. See you in a minute.
In a minute.